Welcome to the Gambone Law Podcast, brought to you by Gambone Law, a Philadelphia-based criminal defense law firm. This weekly podcast is based on questions that we have received from clients and their families. Our law firm is committed to providing the highest level of professional service through aggressive advocacy and serving as a trusted advisor during a tough situation. To learn more about our law firm, read my weekly blog, watch my videos, or download one of my strategy books, visit gambonelaw.com or call 215-755-9000 24 hours a day to schedule an appointment. This podcast is for information purposes only and does not establish an attorney-client relationship. Well, welcome to episode 8 of the Gambone Law Podcast. My name is Alfonso Gambone. Every week we discuss criminal law issues on this podcast, and it is my hope that it will help someone who's faced with a difficult decision. This week I want to discuss pretrial diversion programs. This is an issue that frequently comes up. So like always, I have some questions that I've received from clients and their families, and I want to take them one by one. The first thing I want to speak about, and the first question focuses on the procedure, which is always a common question in this area. So let's see the question here. The first question is, what is the purpose of a diversion program, and what should a person understand prior to entering the program? We have to understand that a diversion program is not simply a free pass. It's not just a get out of jail free card, which is sometimes what it's called. There are conditions which must be satisfied by the individual. There are several pretrial diversion programs available. In Pennsylvania, commonly they are the ARD program, which is called the Accelerated Rehabilitative Disposition Program, the AMP program, which is the Accelerated Misdemeanor Program, a program known as Section 17. There's also the AMP2 program. In New Jersey, there is the conditional discharge method of handling cases. All these cases focus on putting a case in a position where the prosecution hopefully will eventually be withdrawn. So you have to understand that most of these situations, you are put on a different track than a normal criminal case. So following an arrest, typically when you meet with your criminal lawyer, that person should discuss with you the possibility of a diversion program. Now, in most situations, you will not be eligible for a diversion program if your charge or offense involves violence. So situations where you're charged with like felony offenses like robbery, aggravated assault, burglary, typically a gun offense, you will not be eligible for a pretrial diversion program. There are some exceptions. For instance, if it's a simple assault, I have had cases where a person has received diversion programs, but commonly, if you're charged with a violent offense, even if it's a misdemeanor offense, like a terroristic threat of some sort, you will not be eligible for the program. And the reason being is because typically not only does the DA have to offer that following your attorney's negotiation for it, but in many situations, the DA's office will speak to the victim, and in a lot of situations, that victim will not agree to it, mainly because they may have spoken to a civil lawyer who's advised them that if they want to sue you for something, that it's always better to have that criminal conviction as well. Obviously, I don't practice civil law. I'm a criminal defense lawyer, but I know enough about the civil world to understand that aspect of it. And I've handled plenty of cases in the criminal world that have moved on to the civil world in the form of lawsuits against, for instance, police departments, and in some cases, civil rights lawsuits in federal court. Procedurally, for diversion programs, you have to understand that for all programs, normally the district attorney's office is going to require that you waive Rule 600, which in Pennsylvania is also known as the speedy trial clock rule. And what that basically says is that if you're charged with an offense, the Commonwealth has to bring you to trial within 1 year of that complaint being filed against you. one of the conditions of pretrial diversion is that you waive that rule. So it allows the Commonwealth to put your case on a different track. It also means that your case may not resolve in a year. But by waiving that rule, the Commonwealth isn't in a situation where it could be forced to withdraw prosecution because it's violated the speedy trial clock. With regards to the speedy trial clock, it's also important to understand that it runs, but any defense continuances or delays or obviously a waiver won't count against the speedy trial clock. So that's an important thing to keep in the back of your mind. With regards to procedure, every county is going to have a different procedure, but normally it's an application. And during that application, they're going to ask you various questions. The common question is, have you ever been arrested or charged with a crime? And I can't encourage you more to be upfront with your lawyer. If you have something in your past, even if you think it's gone and it's been expunged, tell your lawyer, because if you're not upfront on that application, that in and of itself could really derail your hopes of getting diversion. So the next question I have is, what is the ARD program? Well, the ARD program is the Accelerated Rehabilitative Disposition program I just spoke about. Typically, it's reserved for drunk driving offenses in Pennsylvania. There are situations where ARD is offered for other charges. For instance, I've had situations where it was offered in a simple assault case. Sometimes in a drug case, ARD is offered. And really the way ARD works is that you enter the ARD program, and with that program come conditions. Now, with a drunk driving case, what you'll have is a situation where you're required to complete alcohol and highway safety classes, maybe pay some restitution if there's property damage. In some situations, some counties require community service. Also, in addition, you have to remain arrest-free during the ARD probationary period. You have to understand that during an ARD period, you are on probation. It's really just like probation if you were convicted of something. You have to remain arrest-free. You can't have any new arrests and obviously no convictions. If you are arrested, typically that will kick you out of ARD. There are things that your criminal lawyer can do to maybe keep you in ARD, but I tell all my clients with regards to ARD, when you're on that program, it's really important that you remain arrest-free. Obviously, something like a speeding ticket or running a stop sign probably won't put you out of ARD, but obviously something like a DUI, a second DUI, or a minor drug possession case, and obviously a major case, all would possibly cause you to be removed from the program. If you are removed from the ARD program, it's important to understand that you still have a right to go to trial. So there is still a presumption of innocence. It isn't like you've entered a plea. So if you're removed from the ARD program, your case goes back to the normal criminal trial track. The speedy trial clock begins from the date that you're removed from the program. So at that point, the Commonwealth has 1 year to bring your case to trial. In my experience, most people are removed from the ARD program because of obtaining a new arrest, failing to pay fines, failing to attend classes, showing up late with possible meetings with a probation officer if they have to meet with the person, failing to finish community service. These are all things that are very common reasons for being kicked out of ARD. Now, typically, if you miss an appointment or you somehow don't show up for community service, that in and of itself probably won't kick you out of the program, but they will give you another court date. The judge who's assigned to your case will probably want to ask you a few questions as to why you missed. And it's very important that prior to going into that hearing or that status conference with the judge, that you speak to your lawyer and you explain what happened. Hopefully it's not something like, I just didn't feel like going. But you and your attorney should have a conversation. In situations where I've had clients who have been at risk of being removed from ARD, we always have a phone conversation at least before going in the court so we're all on the same page as far as what happened. Okay, next question. One more thing. ARD, if you complete it successfully, prosecution will be withdrawn from your case. So there is no conviction. And at that point, you can have your record expunged. Regardless of the diversion program you're in, never assume that your record is automatically expunged. In most situations, it is not. Your lawyer must file a petition for expungement with the Court of Common Pleas for that county. Until that's done, it will remain on your record. Not as a conviction, but the arrest will be there. So if you do a background check, it'll show up. It might use the word ARD next to it, but they will still see it. And obviously, the whole point of doing ARD is to prevent that conviction. And you have to understand that for people who aren't involved in the criminal justice system, if they run your record and see an arrest, typically that's where they stop looking at it. So even if it's an arrest that's been prosecution withdrawn, they'll just see the arrest and almost assume a conviction, even though it's not right. So it's very important that you speak to your attorney about that. After you finish the ARD program, there is a little bit of a waiting period. It varies county to county. But if you need a more immediate expungement, your attorney can petition a court for a more immediate expungement and explain why. I've had plenty of clients who are college students and who are going to apply for jobs and don't want that don't want that arrest on their record, and we've made that a reason. And it's a very good reason, obviously. If you're a professional person and you're up for an evaluation of some sort, an annual review, again, all good reasons as to why you want to quickly have that record expunged. Okay, next question. What is the accelerated misdemeanor program, and what is the difference between AMP1 and AMP2? AMP is obviously the abbreviation for accelerated misdemeanor program. Typically, if you're in court in Philadelphia County, which is where this program is offered, you will hear the word AMP1 and AMP2. The main difference between AMP1 and AMP2 is that AMP1 is a first-time offender program like ARD. Typically, if you have a prior conviction, you're not eligible for AMP1 or AMP2. There are exceptions. There's no bright line rule with that, but in most situations, you aren't eligible. Now, AMP1, what happens is, like ARD, you're required to complete certain conditions. Because AMP typically focuses on low-level drug offenses and other low-level offenses, perhaps like a theft or perhaps like even prostitution, solicitation of prostitutes, we've seen people being offered AMP. And the conditions of AMP can be, fines, community service. In the drug cases, typically it's some type of drug treatment which requires you to complete the drug treatment program, and in exchange for that, the prosecution is withdrawn. Again, if your case is in the AMP1 program and you fail to complete AMP1 because you haven't pled guilty to anything, if you fall out of the program or you're removed from it for any reason, because you have a new arrest or something else happens, you aren't at that point going to sentencing. You have your trial rights and your pretrial rights just as if you had been arrested and not entered the program at all. With regards to AMP2, it's a very similar program, but the big difference is that AMP2, typically you're dealing in a situation where you're entering a plea. So unlike AMP1 with AMP2, following a removal for whatever reason, at that point you're going right to sentencing because you have entered a plea. You don't have a right to go to trial at that point. You obviously can appeal, but your appellate rights are very limited because just like any normal plea, you don't really have many appellate rights because you've agreed to plead guilty. So it isn't like a situation where you've gone to trial and filed pretrial motions like I've discussed in previous podcasts. So you have to understand that. All right. Next question. What is Section 17? So this is sometimes called probation without verdict. It's very similar to the AMP programs in the sense that with AMP2, you're entering a plea. With Section 17, typically reserved for drug offenses. Again, you're entering a plea, but you're not being sentenced. If you complete the conditions of Section 17, in exchange for that, they will withdraw prosecution and the case will be dismissed. And that's really what you want. And so you're on probation, but if you do what you're supposed to do with regards to drug treatment, possibly community service, paying fines, the case will be withdrawn. And again, you're eligible for an expungement. But again, just like AMP 1, ARD, Section 17 never assume the expungement. With regards to the diversion programs, again, it's important to understand that with regards to all these programs, you must speak to your lawyer about your eligibility. Never assume it. I've represented so many clients who've told me that they chose not to hire an attorney and go in alone because their buddy or their friend, typically a non-lawyer, will tell them, oh, you're eligible for ARD. Don't waste money on a criminal defense lawyer. Everybody gets this program. Just go there and tell them what you want. Well, it doesn't work that way. And I can't stress it enough that it's worth the money hiring a lawyer. People all the time want to talk about, oh, well, a lawyer could cost you $1,000, $2,000, $3,000, $4,000. But if you think about it in the grand scheme of things, if you're a person who cares about their career or a person who cares about their station in life, or you're trying to get somewhere in life, that money is money well spent. Because if you don't go out and get the proper advice, handle a situation appropriately, you really could have severe consequences for your future. For instance, if you're applying for a job and you did not handle your case correctly and that's on your record and you can't get it removed because you received some bad advice, well, you could be in a situation where you could lose a job, a good paying job or a good opportunity that could literally cost you millions of dollars. So when you think about it that way. These opportunities that you're giving up because you made the decision to simply go it alone. Okay, final question that I have here is, what should you speak to your attorney about when considering whether or not to accept a diversion program? Well, again, diversion program is a great result. For many, it's the logical way to go. It's almost like the perfect result. They're going to withdraw prosecution and move on from there. But you have to understand that there are some situations where you may not want to accept the conditions of the diversion program. For instance, if it requires constant drug screens and you're addicted to some drug, be upfront with your lawyer. Tell them, look, I'm going to have a problem here. I'm addicted to drugs, or I like to smoke marijuana on the weekends. If you're in that situation, again, I'm going to advise you that we have to talk about that and get around it somehow by maybe getting you some help. But it's also important to understand that you can't just ignore it. And many of my clients will say, well, I take marijuana now, I use it, but I can stop. Well, if you're upfront with the ARD department, regardless of what county it's in, if you tell them, hey, look, I smoked yesterday, so if you test me right now, I'm going to come up for it. Prior to entering the ARD program, they're not concerned if the levels are decreasing. It's where the levels are increasing that's a problem. So as long as you're upfront with the ARD probation officer, you'll be in a good situation. Also, with regards to, I spoke a little bit about civil liability, ARD is still going to put you at risk for a civil lawsuit because you're basically admitting that this happened, but you accepted ARD in exchange for not receiving the conviction. So with regards to civil liability, for instance, drunk driving, if the other driver is going to sue you, or in the case of a assault case where you take ARD, civilly, they're going to use that against you. And you have to understand, as I've stated in previous podcasts, all of which are available at gamboneLaw.com, that the civil standard is much lower than the criminal standard. So criminal standard, guilt beyond a reasonable doubt. Civil standard, by the preponderance of the evidence, much different, much less of a standard. That standard is also the standard we use for pretrial motions to suppress and other pretrial motions like habeas motions, all of which, I've spoken on previous podcasts. Finally, regardless of whether or not you're eligible for a diversion program, your attorney should still speak to you about other constitutional rights, mainly your right against illegal search and seizure. If it's a bad stop or a bad search, you want to think about maybe moving forward with it. Now, that's a really risky decision, But I have had clients who've turned down diversion in exchange for going to trial because we've been that confident in the pretrial motion to suppress evidence because we knew, based on the law, that it was a bad stop or a bad search. All these are important questions. Again, never assume, never believe, that you're eligible because of something you read on the internet. Go to a lawyer, speak to a lawyer about your case. If you've enjoyed this podcast, I encourage you to visit gambonelaw.com. All my podcasts are available there. Also, you may call our office at 215-755-9000 to schedule an appointment. Also, if you're watching on YouTube, I'd ask that you consider liking and subscribing to my channel. You will receive updates when we make a new podcast and a new video. I make a podcast every week. Every week I discuss issues that are very important to people charged with the crimes in Pennsylvania and New Jersey. I want to wish you a good look. I want to wish you a good week. I got tongue-tied there a little bit. I want to wish you a good week, and I will see you soon.